My name is Manish Agarwal and I'm a partner at Three Crowns. On behalf of the firm, it is my pleasure to welcome you all to the 9th David D. Caron Praelium, which is jointly organized with King's College and Columbia Law School. Now we gather here today to celebrate the art of advocacy in international arbitration and to honor the legacy of Professor David D. Caron, who was the former dean of King's College School of Law and co-founder of this Praelium. If this is your first Praelium, you may be wondering about the name. And in Latin, Praelium refers to a battle or a contest, specifically a trial of strength. And we thought it was a fitting name for a legal duel where our advocates will fight with the passion of gladiators until the very last rebuttal. And presiding over this battle of words and wits is a very distinguished three-member arbitral tribunal comprised of Hilary Heilbron KC of Big Court Chambers, Sam Wordsworth KC of Essex Court Chambers, and Audley Sheppard KC of 20 Essex. Hilary, Sam, and Audley, we are delighted to have you with us. Thank you very much. As for our advocates, on behalf of the claimant, we'll be hearing from Kate Davies KC of Skadden, and on behalf of the respondent, we'll be hearing from Tariq Baloch of Three Crowns Buildings. Now, having known both of them for more than a decade, we should expect nothing less than a riveting masterclass of oral advocacy. And before I hand the floor to the president of the tribunal, please allow me to summarize the case study just as an aid memoir. And all of you should have the document in front of you. But we are here today in the context of an arbitration that has arisen under an English law-governed sales agreement that was executed in 2015 and provides for a London-seated uncital arbitration before a three-member tribunal. The claimant is the seller, Vito Organics, a company incorporated in the Republic of Corleone. The respondent is the buyer, Freddo Foods, which is a partially owned state company incorporated in the Republic of Brazil. Under the agreement, Vito agreed to sell to Brazil cold-pressed olive oil at the cost of raw olives plus a 15% processing charge, and the way the price was to be determined was through circulation by Vito to Freddo every year of an Excel spreadsheet detailing the price, and then Freddo was to confirm its agreement to that spreadsheet. Now, between 2015 to 2020, Freddo paid the sums due under the contract, but between 2020 and 2022, those payments have been withheld by Freddo on the basis that it could not sell the olive oil to its consumers in Brazil for any profit due to the government pricing regulations. In December 2022, Vito initiated arbitration to recover those unpaid sums, and as the arbitration progressed, Freddo's defense strategy evolved, and a few weeks before the hearing, it was able to seek leave from the tribunal to amend its pleadings to bring a counterclaim for damages on the basis that Vito had failed to comply with its duties of good faith by not adjusting the pricing according to the declining price of olives. Now, at the hearing, during the cross-examination, one of claimant's witnesses admitted that the price notification, the spreadsheets, consisted of two spreadsheets, one of which based the price of olive oil on a fixed cost and was not visible, That was contested, and by veto itself, which showed documents demonstrating that actually both spreadsheets would have been visible to Fredo. That being said, Fredo then applied for disclosure. The tribunal declined the disclosure request. The hearing then proceeded. 6 weeks after the hearing, while the award was awaited, Fredo then wrote to veto, indicating that whatever be the outcome of the arbitration, it would challenge the award under Section 68 of the English Arbitration Act, because the tribunal's rejection of its disclosure request constituted a serious irregularity. Fredo also served a new notice of arbitration, alleging that there was fraudulent misrepresentation in relation to the pricing notifications and the types of olives used, and that it was now going to seek a rescission of the agreement itself. Concurrently with that, there was a derivative claim that was filed by the majority shareholder of Fredo before the High Court of Plassey. And veto has applied to the tribunal for an anti-arbitration injunction restraining both those proceedings, the new arbitration that Fredo has launched, as well as the derivative action that its majority shareholder has commenced before the High Court. So it is in the context of that application that we gather here today for this procedural hearing, where two issues will be addressed. First, whether the tribunal should restrain Fredo from progressing the new arbitration, or simply consolidate that new arbitration into the ongoing matter. And second, whether the tribunal has jurisdiction to restrain the majority shareholder of Fredo from continuing with the derivative claim before the High Court of Plassey. And with that overview, I'm pleased to hand over the floor to our esteemed president. Over to you, Hilary.
Thank you very much. Well, before we enter into our role-playing mode, I would like, on behalf of myself and my colleagues, to say how delighted and honoured we are to be performing this arbitration this afternoon in what one might call, for those who've read the scenario, the Christmas Day arbitration, the request unusually having been served on the 25th of December. And we are delighted, therefore, to be here in memory of David Caron and before this distinguished audience. Just as in recent years, it will have not has escaped your notice that there's been a proliferation of arbitration days and arbitration weeks, viz. The current one that you are all attending. When preparing, as one does for these arbitrations, my research has indicated that there has likewise been a proliferation of national days for food. But unfortunately, we are a few days late for olives, as National Olive Day, and I kid you not, was actually last Saturday. Today, unfortunately, is instead National Fish and Chip Day. So now to the more serious part of the proceedings, and we shall resume our proper roles. Before we do so, just one final comment in that we might be a little more interventionist than we might otherwise have been in order to make the proceedings a bit more lively for the audience. So I now turn to counsel. And we understand that the parties have allocated the time available equally between yourselves. And therefore, Ms. Davies, I understand you're going to start by making the application on issue 1, and you have 10 minutes.
Thank you, Madam President, members of the tribunal and members of the audience who obviously aren't here in the real arbitration because it's confidential being seated in London. You have before you, in relation to the first injunction sought, which is the injunction against Fredo, an application, the ultimate purpose of which is to preserve and uphold the integrity of the proceedings before you, in other words, the existing arbitration, and the enforceability of any award that you issue in these proceedings following the recent hearing on the merits. And that application is consistent with, and I'll come on to it, Article 26 of the UNCITRAL rules. The application, as I say, follows shortly after a hearing in this arbitration in which all issues of liability were, and importantly, were intended to be heard, and in which the prospect of a new claim, in particular in fraud, was trailed before this tribunal. Despite this, and despite the representation to the tribunal that it would confirm whether such a claim was to be pursued by way of fraudulent misrepresentation, in other words, by way of a further amendment, having already amended its case once to its pleaded case, Frido instead purports to raise those very same claims which arise out of matters addressed in this arbitration and which are in essence simply a different way of putting exactly the same points that are already in issue before you, instead in a new arbitration before a different tribunal. Frido apparently seeks to justify this course of conduct by alleging bias on the part of the tribunal. It does so following its own apparent conclusion, which Vito, and I'll come on to this, says is in any event the inevitable outcome of this arbitration, come what may, that it is bound to lose. The allegation of bias as a means to justify Frido's actions is extraordinary in any circumstances, let alone against arbitrators of this tribunal's high standing and esteem. It is unjustified, and it should never have been made. It is also, as yet, just that, an allegation. Unless and until made out, it cannot possibly form the justification for a course of conduct which has been pursued by Frido. In the circumstances, therefore, Frido's conduct is not only a breach of the exclusivity of this tribunal's jurisdiction over the matters before it, it is also abusive and vexatious. Before I address you on these two foundations for the injunction application before you, breach and vexation, it's worth remembering the following in relation to the underlying facts. Vito's claim is a simple claim for payment of the price of goods that have already been delivered and enjoyed over the course of several years by Frido. At all times prior to the commencement of this arbitration, Frido's only defense to Vito's claim for payment of those goods was that it wasn't able to afford them. Avoiding payment is therefore clearly a priority for Frido, even if an illegitimate one. Frido's conduct to date in this arbitration, and now in pursuing a purported new arbitration, is plainly designed to put off that day of reckoning. And it's a day of reckoning that is inevitable. And it's inevitable because whether its claims are put in breach of good faith or in fraud, it has received the goods that it now refuses to pay for. And on that basis, it will have to pay at a minimum a reasonable sum, because Vito will of course have a claim for quantum merit if indeed Frido is successful in its claim for fraudulent misrepresentation. And on that basis, I will now turn to my submissions in relation to the two questions of breach and vexation. As a preliminary note, and in an attempt to simplify the submissions for the tribunal, I've agreed with my learned friend that the proper grounds for the grant of an injunction are indeed breach and vexation, and that the tribunal has the power to grant such an injunction under Article 26 of the rules. I'm also not going to address you on Article 26(3) of the rules. Instead, I rely on my written submissions where the points are set out in full. So turning briefly to breach, and I'm not going to labour this point for reasons that I'm sure will become obvious. This arbitral tribunal has exclusive jurisdiction over the issues and the matters before it. That exclusivity arises out of the negative aspect of the arbitration agreement, as the Supreme Court held in AES. The commencement by Frido of a second arbitration raising the same issues that are before this tribunal in this arbitration is a breach of that negative aspect of the arbitration agreement and the exclusivity attaching to it, which is now within your jurisdiction. That's all I intend to say on breach.
Excuse me, Mr. Davies.
Yes.
Can I ask you, when you say that the issues were before the tribunal, my recollection is a little hazy from the hearing 6 weeks ago, but is it the case that these allegations of fraud, misrepresentation were before us, because I seem to recall that this came out of the cross-examination of the witnesses, and so it wasn't a pleaded issue at that time.
You're absolutely correct, sir. Your memory serves you well. The pleaded case was a case in breach of contract, breach of good faith. But you will recall from Frido's submissions, and I'm quoting from them, that it had entered into the agreement on the understanding, there's reliance, that the price of the olive oil would track the price of raw olives. There is the representation. So while it is absolutely correct that the pleaded case was not yet a case put in misrepresentation, let alone fraudulent misrepresentation, and I'm going to come on to this in the context of abuse, it absolutely was the case that those issues and the foundation for a claim in misrepresentation was before you, and it was therefore open to Frido to have pursued its case on that basis. Now, Frido will say in response to that, well, we didn't have any evidence of fraud, but that's no answer. They didn't need fraud to put a case in misrepresentation, because misrepresentation can be innocent or negligent before you get into fraud, and if they can prove negligence, they get rescission, which is the relief they're seeking in the second arbitration. So it was indeed open to them to have pleaded that in the first case, but you're right that it wasn't pleaded as fraudulent misrepresentation. Does that answer your question, sir?
Thank you.
What about the black olives versus green olives issue? That's new, isn't it? Have you got a case of breach on that?
No, I don't have a case of, well, I have a case of breach in the sense that all of the matters before the tribunal go to whether Frido is required to pay the price under the contract or has a defence to payment of the price. And there really is very little difference between a fraudulent misrepresentation claim put on the basis of spreadsheets which were or were not visible to them, or a case in fraudulent misrepresentation put on the basis of black olives versus green olives. I accept, though, that that issue per se was not raised in the first arbitration. There are, in fact, if I return to my submissions, 3 types of vexatious conduct on which veto relies, although in reality there's significant overlap, at least between the first 2. The first, and arguably the most important for this case, arises where a party like Frido has participated in one set of proceedings and then seeks a second bite at the cherry elsewhere, the purpose of which is to frustrate the determination of the first set of proceedings or simply to multiply and make more complex that first set of proceedings. And the authority for that is the Court of Appeal decision in Star Reefers versus JFC, paragraph 30. Now, while in that case, JFC's conduct in commencing proceedings in Russia was found not to be vexatious, that was because it wasn't bound by a London arbitration or court clause and hadn't submitted to the jurisdiction of the English court or a tribunal seated in London. However, the Court of Appeal recognised that the unconscionability of the foreign claimant is often to be found, mainly or substantially, in the very reason that he did first submit to English jurisdiction as the forum where the parties' dispute will be resolved, and then sought vexatiously to extricate himself from the consequences of that submission, or oppressively to prolong or multiply the litigation by commencing further proceedings abroad. And that's Lord Justice Ricks at paragraph 30. And we say that's precisely what Frido is seeking to do here in commencing the second arbitration. Now, a finding of this type of vexatious conduct is an evaluative judgment, not a discretion. And in this sense, it is very similar to Henderson abuse, which I'll come on to in my second type of vexation. The discretion then comes in at the second stage of the analysis, which is whether to restrain the conduct by way of an injunction. The important point about this kind of vexation is you don't need a judgment in the first set of proceedings in order to find that the second set of proceedings is vexatious, and that comes from the decision of the English court in Ardilla versus ENRC at paragraph 57. In this case, and very simply, Frido's conduct is inescapably vexatious. There can be no debate that Frido submitted to the jurisdiction of this tribunal. It's participated in a full-blown arbitration and a merits hearing. There can also be no serious debate that the obvious purpose of the new arbitration is to avoid the effects of any award rendered by this tribunal. It seeks to invalidate the very contract which, in the first arbitration, it avers. It says in the first arbitration this contract is valid because it claims breach of contract. A breach can only be premised upon a valid contract. In the second arbitration, it seeks to disavow that submission and seek fraudulent misrepresentation and rescission.
Ms. Davies, have you thought further ahead that we've, of course, got to provide an enforceable award? If further down the line there are allegations of fraud, might that not be relevant to enforcement? And might that not be in your interest to have the matter resolved in advance?
The answer to that, I think, is twofold. Number one, if there were facts which had arisen after the award which showed fraud, then yes, that might call into question the enforceability of the award. I think if there are facts which arise during the course of the arbitration, which the tribunal has, for one reason or another, justifiably rejected, then no, I don't think that can affect the enforceability of the award. I think the second point is, if you're not with me on abuse, and if you are with me on abuse, it's a rule of law, and the claims have to be struck out, or the second arbitration should be restrained in this particular case. But if you're not with me on abuse, and I'm sure my learned friend is going to come on to this point and I'll address it in reply, then the proper course is for Frido to seek an amendment of its pleadings, not a consolidation of a claim, which achieves a fait accompli in terms of our right to reply to that amendment application.
What's the authority for saying that abuse is a rule of law?
I'm very glad you've asked me that question, because I searched quite hard for an authority to say that is a rule of law, but the authority is Seal versus Tokyo, which is a 2012 decision, I believe, and I believe, although I will check it if I may in the break, I believe it's paragraph 41 of that decision.
But does that concern a judgment or an arbitral award?
In that case, it concerned a judgment. Yes, correct.
But isn't that rather different?
Henderson abuse can still be applied, and there are two cases in particular I'm thinking of, can still be applied in the context of a series of arbitrations. So where you have a first arbitration which is concluded, you can still have Henderson abuse arising out of a second arbitration if those issues have in fact been determined in the first. I'm thinking in particular of Noble versus Girling and the Injasat decision. In fact, that brings me on to my second type of abuse, which I will take very quickly, which is Henderson abuse. And the most apt example for that type of abuse is indeed the case of Noble and Girling. And I hope, the point is not going to be taken against me, I hope it is now well established as a result of the Court of Appeal decision in Tani versus Musaji, that you can have Henderson-style abuse in different stages of the same proceedings, and that includes in relation to an application to amend, which is in fact the case in Seal versus Tokyo, which I've just referred to. But the most apt example of Henderson abuse, this kind of abuse, is Noble and Girling, in which the insurer, Girling, commenced a second set of proceedings following an initial arbitration in which it had accepted and been found to have provided certain policy coverage. And here's the similarity with this case, it also confirmed to the arbitrators in that arbitration that it was specifically not pursuing a claim in misrepresentation, although it had repeatedly alluded to one. In the second set of proceedings, Girling then did precisely that. It pursued a claim of misrepresentation in relation to the same agreement and sought rescission of that policy. And the English court in that case had no difficulty at all in issuing an anti-suit injunction to restrain the second set of proceedings.
Isn't that a key difference here, that they settle the fence or reserve their rights, might be a more polite way of putting it, at the hearing?
They reserved their right to pursue fraudulent misrepresentation in this reference, not in a second reference. That's the abuse. Having said to you, made a representation to you that they would pursue a claim, they were still considering whether to pursue a claim in fraudulent misrepresentation, in other words, in this arbitration, presumably by making an application to amend. They then changed their mind, having, I suppose, concluded that they were bound to fail before this tribunal, decided instead to allege bias and then commence a second set of proceedings.
Isn't the difficulty that we're in a difficult sort of twilight zone where you say the issue of the validity of the contract is before us and can easily be determined because the defence affirmed the contract. So there's almost no decision to be made on that.
Yep.
If we were to confirm that, but don't we, we're now on notice through the cross-examination at the hearing that there could be a misrepresentation point, there could be a fraud point, the tribunal has questions, notwithstanding the displeasure of the disclosure order, concerning what was disclosed about the two sheets of pricing. We know that's there. Doesn't it put us in a difficult position for us to go on and make a decision on validity of the contract in those circumstances?
Respectfully, sir, no, I don't think it does, because the issue before you is not whether you should admit or shut out a claim of misrepresentation in this reference. The issue is you should restrain the respondent from pursuing that issue in a separate reference. If they want to pursue fraudulent misrepresentation, the correct course is to apply to you to amend their pleadings, and then we have an opportunity to defend that application, including, for example, by saying that it's terribly late in the day and we're going to have to repeat the entire arbitration. Now, you will then have a discretion whether to admit it or not. But the issue here is, should they be restrained from trying to pursue that claim in a different reference?
Mr. Davies, sorry to hog the conscience to my colleagues, but you haven't addressed, and maybe it's something for reply rather than for you to take on, but you have just spoken about what the course of action that the other side should take, but you haven't mentioned the consolidation of two arbitration proceedings, which is expressly provided for in the arbitration agreement in the contract.
Correct, sir. I was going to address that in reply because I believe my learned friend is going to address it in their submissions. So you have my case on Henderson abuse. And very briefly, the new claims arise essentially in the same set of proceedings, albeit through the guise of a new arbitration. They plainly could have been raised earlier. I've already referred you to the piece of their submissions, which, if you recast it as fraudulent misrepresentation, makes it clear that it clearly was in contemplation, or could have been, and should have been, we say. The original amendment to the pleadings was made immediately prior to the hearing when new counsel was involved. Clearly they were looking for ways to try and avoid the agreement. It was open to them to amend, to bring a plea at least in innocent or negligent misrepresentation. They chose not to do so. More specifically, Frido's new case introduced by way of that amendment plainly should have been raised earlier for the reasons given by Coulson J in Seal and Tokyo Insurance, namely, and I know I haven't taken you to it, but in that case it was clear that the hearing which had just occurred was intended to address all issues of liability. That is the hearing we have just had 6 weeks ago, as evidenced by the fact of Frido's amendments to its case immediately prior to that hearing. They clearly thought everything had to be resolved. That's why they amended to bring a new counterclaim. It is particularly objectionable for Frido to seek to pursue a claim in a separate arbitration, the prospect of which it raised before this tribunal, which I've already addressed you on. The third type of abuse, which I'm going to address under the heading of the second issue, is Frido's procurement and support of the pursuit by Sunny.
I know we've interrupted you, but
that's it. I've got two more words to say. The third type of abuse is the pursuit, the support of Sunny's pursuit of the Brassey High Court proceedings. Thank you very much.
Ms. Davies. Mr. Baloch.
Thank you. Good evening or good afternoon, members of the tribunal. Let me begin by thanking you for convening at this late hour to hear these two pressing applications. In response to my learned friend, I'll be following the same structure as she did, except with one addition, which are my submissions on consolidation. I'll begin by saying some words about the test for the anti-arbitration injunction, or AAI for short. Sometimes I may use that short form. Broadly, we are agreed with, I would submit some modification that's required because you are a tribunal and not a court. Second, I'll explain why the test, when applied on these facts, does not justify an anti-arbitration injunction. And finally, in the alternative, I will explain that if you are minded to grant an anti-arbitration injunction, then you should instead consolidate the two proceedings. Members of the tribunal, let me start with the first issue. I agree with my learned friend that this tribunal has the power to order an AAI for the reasons she gives. I have a small disagreement on the question of when this power can be exercised. And that means I would articulate the grounds somewhat differently, the two grounds she says that justify an AAI before the courts. Let me explain briefly why. In the arbitration context, there is very little by way of precedent or commentary on how or when this power to grant an anti-arbitration injunction should be exercised. And given you are a London-seated arbitration under an English law-governed arbitration agreement, a good starting point and a wise one is to say you should take the lead from the practice of the English courts. And that practice shows that an anti-arbitration injunction is available when the pursuit of the arbitration infringes on the applicant's legal or equitable rights, or when the pursuit of the arbitration is, and I quote, vexatious, oppressive, or unconscionable. But I would caveat that with 2 points that my friend did not refer to, and I think are noteworthy. The first one is that while there may not be consensus, or perhaps even more accurately, any visibility on the test applied by tribunals, what there is consensus on is that any power to issue an anti-arbitration injunction is truly exceptional. In Claxton and TXM, Mr. Justice Hamlin, as he then was, said, the authorities indicate that such injunctions will generally only be granted in exceptional circumstances. This is consistent with the doctrine of competence, and with the principles of the law of international arbitration agreed under the New York Convention. And that point is even more true when an arbitral tribunal is being asked to issue an anti-arbitration injunction. Professor Berman, in a much-cited article on the subject, said, although issuance of an anti-suit injunction, by which he included an anti-arbitration injunction, by a national court may be exceptional, even more exceptional is the issuance of an anti-suit injunction by an arbitral tribunal. My second caveat, and where I would modify the test, is I'd submit that the AAI that I just articulated from the courts needs to be modified, given you are not a court. And what do I mean by that? The second ground has been described as vexatious, oppressive, and unconscionable conduct. That's what it tries to restrain. But in the very recent case on anti-arbitration injunctions in the English courts, and I'll mispronounce this, in Soderszewinski and Gerald Martin, Mr. Justice Foxton described this second ground as being based on the, and I quote, the jurisdiction of the English court to prevent the wrong of vexatious, oppressive, and unconscionable conduct, end quote. A tribunal does not have the same policing duty. The court, as a supervising court, and with one eye on it being a public service with obligations not just to the parties before it, may have notions of vexatious or oppressive conduct that are different to a private tribunal. And that has two consequences. First, you need to be careful before transplanting the learning of the English court cases on anti-arbitration injunctions to your context. Sometimes those cases represent the English court exercising its supervisory jurisdiction. Plainly, that is not your role. Second, I submit you need a test for this second ground that is more focused on your context as a tribunal. And here I would commend to you the suggestion of Professor Levy in his article on anti-suit injunctions, and again, when he says anti-suit injunctions, that encompasses an anti-arbitration injunction in his paper, and he says that arbitrators should only issue anti-suit injunctions when it comes to their attention that one of the parties has committed fraud or otherwise engaged in abusive behavior in order to revoke the arbitration agreement. And this can be, and he carries on, this can be the case when there is an abusive petition for interim measures designed to paralyze the arbitration, or when there is an attempt to slow down the proceedings or to harm the interests of another party, as is well illustrated by the Turner and Grovick case.
I mean, with respect, why are the circumstances here not exceptional, and why is the conduct of the respondent not potentially abusive?
Well, so I was just going to set up the test, because I wanted you to have in mind, and I think one of your questions suggested that when you were trying to understand, when you asked the question, is that a court or a tribunal? I wanted to give you a focused test. In the end, even if you apply the test of my learned friend, and as I'm about to show you, I would submit that the facts here do not expose abusive behavior that would engage either on the court test or the test I commend to you as justifying an anti-arbitration injunction. And I'm going to just go through each of the sort of categories that my friend took you through. But can I just begin by explaining why this is not the first ground, which is a breach of the arbitration agreement, unless you want me to move on straight away to abuse. But I think I should do that just so you have Fredo's submissions. Now, my friend invokes AES and Kaminskork about the dicta in that case from the Supreme Court about the negative and positive aspects of an arbitration agreement and how this means that claims subject to an arbitration cannot be brought in a different forum. And that is obviously right, but concerns a different situation to the one you're in, where a dispute, in that case, it was about a dispute that the parties have agreed should be arbitrated and is then being prosecuted in the wrong forum, such as a court. That is obviously a breach of the arbitration agreement. In the present case, Fredo is not breaching the arbitration agreement, but in fact acting consistently with it by commencing the new arbitration under the same arbitration agreement. My friend analogizes AES with the situation before you. She argues that once a tribunal is seized of certain disputes and facts, their jurisdiction in relation to those matters is exclusive, and no other proceedings can be brought in relation to them, even under the same arbitration agreement. Members of the tribunal, I make 2 points there. First, the key word is seized. We say you have not been seized of the new claims. They are, and the questions expose that, the fraudulent misrepresentation claim is not before you, and the claim that the wrong olives had been used for the oil is also not before you. My learned friend tries to get around that, as she did when you asked her questions, by arguing that elements of the facts that may go to those two claims are before you. But one has to be precise about what is or is not referred to you in terms of claims. This is because your jurisdictional mandate is delimited by the claims and defenses put before you. As a leading text puts it, the tribunal's jurisdiction is defined by the issues that have been referred to arbitration. Arguing that elements of the facts that go to these claims or before you is not enough. It would create havoc if that was a test assessing what claims are before you.
Well, claims, but doesn't a tribunal have a duty in some circumstances to explore certain issues if they arise during the course of the arbitration? Fraud, illegality, for example?
Well, but in order to write an award and make any findings in relation to it, you would have to obviously have some sort of consent by the parties that was a claim put before you.
Really?
I mean, if you're saying that you could ask the questions and then write an award about a cause of action which has not been put before you, I would suggest that would not be the safe course to follow.
Well, let's put it another way. If the tribunal had concern about the enforceability, as the President mentioned, and had concerns, wouldn't it be a better course for the tribunal to press the parties to address it on that?
And exactly, and I would hope that the parties would listen, but you would either formally say, can you please add that as one of your claims, or I suppose you would say that by virtue of both parties addressing you on that course of action, it is now within the reference. But that is not the case here, I would submit. Both those claims are not before you.
Perhaps jumping ahead, but one of the factors in the context of Henderson and Henderson would be to see whether or not there was new evidence or new material. What we don't know is whether or not, in fact, the material upon which you're basing your second arbitration is exactly the same as the material you had before us, but you said you wanted time to consider. Yeah. And instead of considering it and coming back and making an application, I think the word was imminently, your clients waited 6 weeks and commenced a new arbitration. So what are your comments on that?
Well, I'm going to come to that now, but can I just give you a preview? Part of the reason why I framed the test as I did, because I wanted to focus it on what an arbitration, what a tribunal and its powers are, and more appropriate compared to a court is, because I submit that Henderson estoppel is not a valid basis to issue an anti-arbitration injunction against another tribunal. That is a question that could be within the jurisdiction of the second tribunal. It's a question of a preclusion, not a basis for an anti-arbitration injunction, because as a tribunal, you have powers within your own jurisdiction, and the upcoming tribunal, or the tribunal that will be formed, that's the kind of objection that you would make before it by saying that this is something that has already been decided or could have been decided based on Henderson estoppel. But I'll come to that if I may. So that's the first ground, members of the tribunal. I submit that there is no breach of agreement. So if my learned friend will succeed, it has to be by showing you on her case vexatious oppressive conduct, and what I say is a modified test, fraud or abuse that invalidates or undermines the arbitration agreement. I'll just quickly go through the different classes of abuse that have been put before you. The first was to frustrate the arbitration and the multiplicity of proceedings. I think one has to be careful there, because simply saying multiplicity of proceedings, I would submit, is not enough for abuse. It may be from a court's perspective, because they have a different sort of perspective, which is, as I say, to police vexatious conduct. But one needs to have something more. And in Ardilla and ENRC, which is one of the cases my friend relies on, the AAI applicant successfully injuncted a party that commenced new proceedings in another court, designed specifically to frustrate the ongoing Part 24 claim in England. That's what the judge found. It was not about proceedings in the same arbitration, and we say Frido's claim was not commenced to undermine the case before you, but rather to prosecute the claims that have emerged in the evidence. My friend also referred to Excalibur in Texas as an example of a case where vexatious conduct was found in the context of parallel arbitrations, but that case is not about parallel arbitrations. It was about parallel court and arbitration, and one of the factors motivating the anti-arbitration injunction tells you everything you need to know about why that case is not relevant here. And I'll quote the judge. One of the reasons he gave the AAI was because, and I quote him, it would be vexatious for TKI and the Gulf defendants to be forced to defend two sets of proceedings involving the same issues in two jurisdictions at the same time, and further that he found there was strong evidence that the defendants were not parties to the arbitration agreement. Again, that's not the case here. This then brings me to the Henderson ground, which Madam President raised with me. We do not deny that Henderson estoppel could apply to arbitration. But as I said, this would not justify an anti-arbitration injunction by this tribunal. Rather, it would be for the new tribunal to assess the merits as an estoppel defense. And this is a good illustration of the difference between the test applied by the court on vexatious and oppressive conduct and the test I'm commending to you for this second ground. While a court may find a Henderson-type situation vexatious or oppressive, that would not be the case under the test I say should be applied, which is fraud or abuse designed to revoke the arbitration agreement. But even if you accept that Henderson abuse could potentially be the basis of an AAI, I submit that that is not the case here, because one needs to look at how the Henderson rule works. It is not supposed to be applied mechanistically, and I think that's why Mr. Wordsworth was asking about the rule of law. Whatever that means, if it means a scientific rule which allows for a binary answer, that is certainly not the case with Henderson. And if I may, the learning on that is pretty clear, but let me just quote Phipson, which has synthesized the relevant court cases and the commentary. And the quote is, "A decision as to whether to strike out a claim on the basis that it should have been brought in previous proceedings is a decision involving the assessment of a number of factors to which there is only one correct answer as to whether or not there is abuse of process." So yes or no to abuse of process. But what does that mean? As opposed to a decision involving the exercise of discretion. The court should adopt a broad-based merits approach. The fact that the defendants to the two sets of claims are different is a powerful factor, but no bar to a finding of abuse. No distinction should be drawn between the original cases concluded by the settlement or judgment. The fact that the claim could have been raised in the original action does not of necessity mean that there is an abuse. The fact that a party did not behave culpably or improperly should be taken into account. And as this passage shows, one has to take a broad-based merits approach. So contrary to my friend's analysis, just because a claim could be brought in a previous action does not necessarily mean there is abuse. the touchstone is abuse. And so let me explain to you why I would, sorry.
Can I just interrupt on that point? The parties in their arbitration agreement provided for the possibility of what happening on the basis that there was common questions of law and fact. To what extent can we take account of the fact in looking at abuse as opposed to, say, breach, of the fact that the parties did actually consider that this might happen, but instead, albeit that it was not mandatory, your clients went ahead and started another arbitration?
I would say it's positive in favour of Frido, and you can take it into account because a broad merits-based approach indicates, when you look at one of the factors, which is the agreement, that you may consolidate them, but you may not, and that there may be claims out there under the arbitration agreement that may have commonality, and that is not unusual in arbitration. So my answer is yes, you can take it into account, and I would submit that it's in favour. It indicates in favour what's happening is not abuse. And if I can give you some more examples.
Sorry,
please.
just trying to understand sort of the bigger picture. Our President has been very diligent in writing the award reflecting the view of the tribunal. But given the pleadings, that award might affirm the parties were agreed that there was a binding contract. If we issue that award, where does that leave your rescission claim? Doesn't that raise judicata?
Well, I would submit, I would try and persuade
The other tribunal.
That's not the case for the reasons, and of course I would challenge your award, which I've already indicated in the letter. But can it's obviously difficult for you because one can spin these facts in alternative ways. So can I just end this part of the submissions in explaining why we don't see this as abuse? It's strategic, it's tactical, but as the President said, an aspect of that is already envisaged in the clause accommodating consolidation. Sorry, yeah.
In doing so, can you try and reassure us that this is not a form of collateral attack on our future award? Because I think that's what's troubling me at the moment. And you can see that's a real issue in certain of the cases on Henderson and Henderson, and in the various commentators on Henderson and Henderson, in the specific context of arbitration, like Landau's well-known piece.
Yes. Can I start with that? Undoubtedly, if my client is successful in the second arbitration, it does undermine any award you issue saying that there is a valid arbitration, which proceeds on the basis that there is a valid contract. So you may say, for that reason, you may take the view that I'd rather consolidate them, and that may be your decision, because that is one of the alternative requests that I'm making to you. But I cannot assure you any more than that. It's a two-way process, I suppose. We are in a situation where certain things have come out in cross-examination. We have asked for disclosure. We have asked to cross-examine a witness that has been introduced late. Those two things are necessary for us to properly present and fairly present a potential claim on fraudulent misrepresentation. If we're not able to do that, the situation is that we have no choice but to start a new reference.
I'm just looking at the time, Mr. Baloch.
Yeah.
How much longer have you got?
I just wanted to end by saying a few words on consolidation as the alternative.
Well, briefly, because you won't have much
Well,
time for the next issue.
if you are minded to issue an anti-arbitration injunction for reasons that could even be the collateral attack point, then I would urge you to consolidate these proceedings. The common question of law, in fact, is not hard to conceive. It could simply be, is Veto owed the money they are? We say no for the three different grounds: good faith, fraudulent misrepresentation, the wrong olives being used.
Don't you have a problem because you've got a different arbitrator?
Well, and this is how I was going to end.
I won't say which.
No.
Of my
This
colleagues.
is how I was going to end. If you are minded to give an AAI, but you are open to consolidation, then we would have to discuss the withdrawal of that nomination in order to make this work. Those are the end of my submissions on issue 1.
Ms Davies.
Thank you very much. Just a few points in reply. Number one, on this amended or modified test for the second limb of the relief or the power that you have, it's suggested that there should be some higher test because you don't have the police powers that the English court has. That's wrong, at least as far as this arbitration is concerned. Article 26 2b makes it clear that you can order relief to prevent or refrain from taking action, prevent a party or refrain a party from taking action that is likely to cause current or imminent harm or prejudice to the arbitral process itself, which leads to my second point, which is the concern about your award. This is precisely a sort of anticipatory Henderson abuse in the sense, as Mr. Wordsworth said, in the sense that it will undermine the efficacy and the enforceability of your subsequent award. My learned friend's response to that, as entertaining as it was to suggest, well, yes, I am going to challenge your award, so it doesn't matter. That's an extraordinary submission to make, and it puts the cart before the horse. The issue here is that Mr. Baloch and his client Frido think that this tribunal is biased. That is the issue. If that is indeed something which he wishes to pursue, he should make an application under Section 24 of the Arbitration Act and have it resolved so that the proper forum for the resolution of this entire dispute can be resolved.
I think you can take it we're not a tribunal who will be affected by in terrorem allegations.
My learned friend also said this is a case in which a Henderson abuse shouldn't apply because it's an issue for the second tribunal. In other words, Henderson abuse is a defence to a claim. It isn't a ground for injunctive relief. That's not an answer, because even if it's right, I still have my first and my third grounds of vexation, which is the parallel litigation and the fact that Frido is supporting Sonny in the pursuit of the Brassey High Court proceedings. As to consolidation, and I will try to keep this very brief, there can be no question of consolidation if there's abuse, for the reason I've given. And to your question earlier, Mr. Wordsworth, about whether abuse in the Henderson sense is a rule of law, I refer you to paragraph 40. I was right on the paragraph number, I was wrong on the case citation. It is paragraph 48, but it's the Kensel and Corey case, which was decided in 2020, which said that Henderson abuse is a rule of law in that sense.
In the arbitral context?
Not in the arbitral context, no. That's an English court judgment. But regardless of abuse, the reason why you shouldn't order consolidation is because it bypasses very significant procedural rights that veto has in relation to the new claims being advanced. The proper course, as I've already said, would have been for Frido to apply to this tribunal, as was indeed trailed at the hearing, to make an amendment to its existing pleadings. Had it done so, veto would have had available to it a multitude of defences to that application, including that the claims are raised very late. And I've already said why I think the claims are raised very late. An application to amend is late if it would require the duplication of steps already taken in the arbitration. An application to amend is very late if it would postpone the hearing. Here, there's no question of postponement. We would have to completely re-arbitrate the entire proceedings on the very same facts. This is not a question of commonality of issues, which my learned friend sought to suggest.
But isn't it going to be said against you that it's late because of hidden impropriety? Right or wrong, but that would be said against you as to the explanation. So it's not really late, it's been made.
Sir, in response to that, I would say it's late because of a change of counsel on the part of Frido. It was only upon the change in counsel that Frido chanced upon the idea that it might have a counterclaim, and it chose to frame that counterclaim as a claim of breach. It sought disclosure on that claim, and it got it. Had it thought to make its claim in fraudulent misrepresentation, or indeed just misrep, which I've already said was open to it, it could have made disclosure, and it would have got that application. It would have been successful in that application as well, because you granted that disclosure order. So the reason it's late is actually because of the change in council, not because the issue has arisen late.
But we are talking here about allegations of fraud, and it may be, we don't know, that for the second arbitration, council has found himself in a position to plead fraud, whereas before he couldn't. Now, that being the case, if on your scenario, an application had been made or was still to be made in this arbitration, what would your answer be?
My answer would be, well, the fraud allegation in the second arbitration arises directly out of this arbitration. The fraud is said to arise out of the concealment of the first of the two sheets in the Excel spreadsheet, which was the subject matter of cross-examination in the first arbitration. And that is why we say it's an issue that should be resolved here.
Do we know if there's any additional evidence?
There may well be additional evidence. An application was made during the hearing before you, and for the reasons that you gave at the time, you denied that application because you said it wasn't actually relevant. You'll remember...
No, well, I recall that.
Yeah, you'll remember we showed you several emails which actually showed that both sheets were visible. So the issue is moot. The entire foundation for the claim of fraud is manufactured in order, as I said earlier, to push off that inevitable day of reckoning, even if they're right about fraud, because we will have a counterclaim in quantum merit. And that's what this really is all about.
Well, does that conclude your
That concludes my
submissions?
submissions.
Well,
Thank you.
Thank you both, counsel, very much for your submissions, and we will consider and revert. But meanwhile, I think we need to move on to issue 2. And I think, Mr. Baloch, you're going to start on that issue.
No, I think...
Oh,
No,
you are,
Yes,
right, because
it
my
remains my
running order said it was the other way around. I thought there'd been some agreement.
There was, but I think we may have been
We
recorded
reversed it.
incorrectly. Apologies for that.
Thank you, Madam President. So, as the second issue remains my application, an application for an anti-arbitration injunction, this time against Frido's majority shareholder, Sonny, who is not taking part in or has not taken part in the arbitration to date. So, as that is my application, I will go first. The power to grant this relief remains the same power that we've discussed in relation to the first issue, and the parties are agreed on that. In addition, however, the test for determining whether the foreign proceedings brought by Sonny are vexatious is whether there has been collusion between Sonny as majority shareholder and Frido. If there has been, case law is clear that an injunction may be granted, obviously within your discretion. The first case in which the courts granted such relief was the 2011 case, which is now known as Russian Machines, BNP Paribas versus Russian Machines, upheld by the Court of Appeal a year later. In that case, a dispute arose under a guarantee entered into by the Russian entity, Russian Machines, in favour of the bank, providing for English law and LCI arbitration. Arbitration proceedings were commenced by the bank to enforce the guarantee. A few weeks later, and just 7 days after the claimant in the arbitration had filed its statement of case, an unrelated entity who was trustee manager of a majority shareholding in Russian Machines, but under the same ultimate beneficial ownership, commenced proceedings in the Moscow court seeking the invalidation of the very same guarantee, on the basis that the guarantee should have been but was not approved by the board of Russian Machines. The trustee manager was not a party to the arbitration agreement in the guarantee. In upholding the injunction to restrain the pursuit of the Moscow proceedings by the trustee manager, the court at first instance and then the Court of Appeal was satisfied that the trustee manager had colluded with Russian Machines to preclude or render more difficult the bank's enforcement of any arbitration award. And the collusion was said to arise because of the common control between the two entities, the participation of the respondent in the arbitration in the Russian proceedings, in which, although the respondent in the arbitration was also a defendant in the Russian proceedings, had nevertheless supported the claims of the trustee manager. So the common control of the parties, the importance of the underlying transaction, the guarantee, the timing of the action, and the improbability as a result of timing and common control of the trustee manager acting alone. These are therefore the same factors that you should consider in determining whether Sunny should be restrained in this case on the basis of collusion.
How can we make an order against Sunny?
I'm going to come on to that. I'm going to come on to that, if I may. There's just one more case I want to refer you to because I think it's relevant in this context, and that is Mace versus Rettensell, which is a 2016 decision of Justice Phillips, in which he said that the existence of common control, common ownership and control is in all cases determinative absent any other facts to the contrary. So facts, for example, which would show, so if for example, Frito had written to Sunny and said, you should withdraw these foreign proceedings in the Brassey High Court, that would be the kind of fact that would lean against the presumption that common control leads to of collusion. So turning to the issue, there is a two-stage inquiry. The first stage of the inquiry is to ask whether there has in fact been collusion, such that Sunny's commencement of proceedings in the Brassey High Court is vexatious. If you find that it is, that is also, as I alluded to earlier on my third ground of vexation in relation to issue 1, that is also vexation against Frito on issue 1. In my submission, there can be no serious debate about collusion in this case. Sunny is not only a related company, it is the majority shareholder in Frito and therefore has de facto control over Frito. Moreover, that de facto control arises not just because of the related nature of the two entities, but because both companies have exactly the same board members. Sunny and Frito both have 9 board members. Sunny has 1 additional board member who's a non-executive director, but they have exactly the same board, so decisions are made in common between the two entities. They are therefore under common ownership and control, and Sunny has complete control as the majority shareholder over Frito's corporate decision-making. The conclusion, as Justice Phillips said in the Mace case that I just referred you to, that this is determinative of collusion, in this case is reinforced by the timing of the Brassey Court proceedings. You will recall that the notice of arbitration was received 6 weeks after the conclusion of the hearing, and service of the Brassey Court proceedings occurred the very same evening. As Justice Phillips said in the Mace case, the idea that that is coincidental is purely fanciful. If further reasons were needed, the object of the Brassey proceedings is to invalidate the agreement, to render it void ab initio, just as Frito seeks to do in the second arbitration. That is again a collateral attack on your award arising out of the recent hearing. While the grounds for doing so by Sunny may be different, the underlying object is exactly the same. The agreement and the outcome of this arbitration is therefore clearly important to Frito, otherwise why seek the invalidation of the agreement? Indeed, Frito has accepted that it cannot afford to pay the price owing to Vito, whether as a price under the contract or in quantum merit, so it is a matter of survival for Frito. It cannot be more important, and that's one of the factors the Court of Appeal emphasised in the Russian Machines case. And as the Court of Appeal also emphasised in that case, if the Brassey claim proceeds, its effect will be either to render Vito's claim in this arbitration more difficult, because you will render an award that will be met with a claim that the agreement is in fact void, or worst, to preclude enforcement of any award at all, in particular in Brassey, which is where enforcement will take place. That is the very definition of vexation. There can therefore be no serious doubt that Sunny's pursuit of the Brassey proceedings is collusive and therefore vexatious. That is stage 1 of the inquiry. We now come on to Mr. Sheppard's stage 2 of the inquiry, which is whether you can order Sunny as a non-party to the arbitration to withdraw those proceedings. Now, I'm not going to sit here and tell you that you have jurisdiction over a non-party to the arbitration agreement. Sunny isn't a participant in this arbitration, and I wouldn't seek to suggest that you would have jurisdiction to order against them if they weren't a party to the arbitration agreement, irrespective of their participation. However, in this case, and in Vito's submission, and I'll take this point very briefly, Sunny is in fact bound by and therefore a party to the arbitration agreement. While it's accepted it's a non-signatory, Sunny is incorporated in Delaware, And under Delaware law, as the place of its incorporation, which goes to its capacity, Sunny can be a party to an arbitration agreement on the basis of veil piercing. Now, unlike English law, under Delaware law, veil piercing does not require fraud. All you need is evidence to show that Sunny dominates Fredo, or evidence which shows no separateness between the two entities. And the citation for that is Thompson versus American Arbitration Association, which is a case of 1995. Sunny and Fredo have the same board, as I've already said, and clearly there is no separateness, evidenced by their collusion in bringing the Brassey proceedings. And on that basis, we say you can make the order against Sunny. But you don't need to be with me on that point, you'll be pleased to hear. Because I have two alternative suggestions for you which achieve the same outcome. And the outcome here is to avoid the effect that Sunny's pursuit of the Brassey High Court proceedings will have on this arbitration and, importantly, your award and the enforceability of it. And in veto submission, there are two things that you can do, and they're not mutually exclusive. The first is, if you're satisfied there has been collusion at the stage one of the inquiry, if you're satisfied there has been collusion, but you can't grant the relief sought because you conclude that you don't have jurisdiction over Sunny, veto will apply to the English court for the same relief, and veto asks for this tribunal's blessing that it do so. I frame it as a blessing rather than seeking your permission because, of course, you will know that the court's anti-suit relief arises under Section 37 of the Superior Court Act and not Section 44 of the Arbitration Act. So I don't face an issue under Section 44.5, nor do I face the issue arising out of the Gerald Metals case. There's also no provision in the UNCITRAL rules, unlike the LCIA rules, to preclude veto taking such a step. And that's why I say I seek your blessing rather than your permission. At the same time, and we do ask for this order as well, veto asks that the tribunal order Fredo to procure, in the sense of seeing to it, that Sunny withdraw the Brassey proceedings, and if it fails to do so, that Fredo be awarded damages for breach of that obligation. Those damages would, of course, be the ordinary damages for breach of an arbitration agreement, i.e. costs arising out of the defence of the Brassey proceedings and indeed this application.
Isn't it a similar point? How does a subsidiary procure a parent?
Well, that's a good question in an ordinary case, but here we've already seen that Fredo is perfectly capable of procuring that Sunny does things because Sunny's commenced the Brassey court proceedings. And that's one of the reasons why we say there's no impediment to such an order. The other obvious reason there's no impediment to such an order is because this tribunal does have jurisdiction over Fredo, even if it doesn't have jurisdiction over Sunny. And those are my submissions, unless you have any other questions.
I was just going to raise this point in that we know that the olive oil is a regulated commodity in Brassey. What surprises me is that the issue of various compliances going up the chain has not been actually raised in this arbitration before. Are you able to explain why this has come about really rather late stage in the arbitration?
I'm not, madam, unfortunately, because I'm not privy to Fredo's decision-making. That may be a question more appropriately directed.
Say this, that if it's something that's in the contract, surely that you would want to ensure that there was compliance with it, given that it's regulated by a state.
But I'm not sure
in part.
I'm not sure this is a question of, this is a regulatory question. I think Sunny's claim in the Brassey High Court proceedings is that there wasn't board approval.
Yes, but I think it goes, I may have misread it, says that under Brassey law, a regulated commodity requires shareholder approval. But in any event, you can't shed any light on it. Maybe Mr. Baloch will be able to assist us.
No, Madam President, I can't.
Mr. Baloch.
Thank you, Ms. Davies. As before, I will follow in responding the structure adopted by my learned friend. I'll first comment on the relevant test, and unsurprisingly, I have something to say and to modify that test. I will then apply that test to the facts to show why an ASI an anti-suit injunction is not justified. And I'll spend some time on the power or not you have to issue the order against Sonny or indirectly via Frido. So can I just come to the first test? The two grounds are still there, as I previously submitted. Breach of a legal right. Ms. Davies says vexatious or oppressive conduct. I say fraud or abuse. But I think there is one modification that the courts have adopted, which is in fact relevant here. And that is summarized in the book by G on injunctions. And I want to read it because I think it's clear why it's important in this context where you are being asked to issue an injunction against a foreign court proceedings. And it's this: outside cases governed by a contractual clause, i.e. the breach, the ground one, if the question is which court should hear and determine the underlying substantive dispute, an alternative forum case, then whether the English court is clearly the most appropriate forum is a starting point or threshold question. If the threshold question is answered in favor of England, then the court considers whether the pursuit of the foreign proceedings is vexatious, oppressive, or unconscionable, or whether the ends of justice require the granting of the injunction. Unless this further element is present, an injunction will be refused. Now, applied to the arbitration context, what G is saying is this: if the ASI applicant says that the foreign proceedings should be halted in favor of the arbitration, as Ms. Davies is saying, and the basis for your ASI is not that the proceedings breach the arbitration agreement, which Ms. Davies accepts, then in order to rely on the second vexatious ground, or the second ground, which is vexation, as Ms. Davies says, you first have to show that this arbitration would have been the more appropriate forum for the dispute currently before the foreign court. And only if the answer to this is that the arbitration was the more appropriate forum, only then do you get to investigate if those foreign proceedings are, on Ms. Davies's test, vexatious, oppressive, or unconscionable, or as I say, fraudulent or an abuse. And this threshold question is never addressed by my learned friend, and it is, I submit, fatal to her claim. And this is because she is not claiming that the foreign proceedings are a breach of the arbitration agreement. In these circumstances, we don't get to the question of vexatious conduct on her analysis unless she can show that this tribunal is a more appropriate forum for the dispute before the Brazil court. It's obviously not, because that court is addressing whether you call it a regulatory matter or a company law matter as a matter of Brazil law. And that, my client says, is a perfectly legitimate claim to be prosecuted there. And the fact that there may be conflicts or inconsistencies is just a fact of international dispute resolution. It's certainly not a reason to issue an anti-suit injunction. So our first submission is that that threshold question or that threshold is not passed. But even if it was, on these facts, an ASI is not justified. My learned friend pointed to the case of BNP Paribas and Russian machines. That case is fact-specific, and I go back to my warning about being careful about transplanting some of these court cases and judgments over to this particular context of arbitration. It was also not a final decision, but on an interim application where Mr. Justice Blair made clear that he was not applying the balance of probabilities test, he found that there was collusion between one of the parties to the arbitration agreement and related parties to impede the outcome of the arbitration. We submit you don't have evidence of collusion. Timing, commonality of control and ownership on their own, because there's nothing more, do not evidence collusion. And you are being asked to make a final, not an interim order. And even then, you're being asked to do that on the balance of probabilities. You do not, I would submit, have the evidence to say that there is collusion here. So let me then address finally the point about whether this tribunal has jurisdiction to issue an order against Sonny or indirectly on Sonny via Frido. My learned friend rightly accepts that this tribunal would not have jurisdiction to grant an ASI against a non-party. To get around that, she relies on Delaware law, but there are two fundamental problems with that. First, since at least Peterson Farms and C&M Farming, the question of whether a third party can be made a party to the agreement is governed by the law governing the arbitration agreement. In this case, that is English law. And in Peterson Farming, the eminent tribunal had applied a group of companies doctrine based on international practice to make findings impacting a third party to the arbitration, and the award was successfully challenged on the jurisdiction because a group of companies doctrine applied by that tribunal was found not to be part of the governing law, which was the same as the English law. This means that Delaware law cannot be invoked here to help veto. And English law has not been pleaded for good reasons, since it would not allow Sonny to be made a party to the arbitration agreement.
Are you saying, are we bound by that, or we should be informed by that? And if we're to be informed, should we take cognizance of the recent Indian Supreme Court decision on group of company doctrine?
I would say, sir, that you are bound by it to the extent that the same fate could impact this award if you were to apply a law that is in the governing law of the arbitration agreement. And because the English law, in light of the recent judgment, hasn't been pleaded, it's difficult for me to answer in abstract. But I would suggest that even the limited grounds on which the corporate veil piercing is allowed is not present here. And my friend Fairley does not go down that road herself. But there's a second problem with the way that the Delaware law point is made. The typical fact pattern would be to veil pierce Frido in order to reach the shareholders behind him. And Frido is, of course, a Brasi incorporated company. But by arguing for Delaware law, Vito wants you to pierce Sonny's corporate veil, and Sonny's not before you for that to happen. So I don't even think, just in the way the argument is even framed, helps you, even if you were minded to apply Delaware law. And perhaps acknowledging that, you have two suggestions. One is for a blessing. I have nothing to say on that, but if you are in the business of giving blessings, then there's a few that I would ask of you. And second, my friend asks you to order Frido to procure Sonny to withdraw the Brasi proceedings. This is seen as a neat workaround because the tribunal has jurisdiction over Frido. Now, in support of this procuring obligation, my learned friend had cited Nearfield and Lincoln. She doesn't do that now, perhaps for the reason that in that case, procuring was actually in the contract. That was an obligation. That's not the case here. Members of the tribunal, am not aware of any authority allowing for such a workaround in the principle that you only have jurisdiction over the parties to the arbitration agreement. But can I just attack it on first principles? It's worth reflecting that a court or tribunal never actually really directly injuncts a court or tribunal when it issues an ASI or an AAI. The injunction is in personam, and as Professor Berman said in the article that I mentioned earlier, while anti-suit injunctions are never directed to the foreign court or tribunal itself, but rather to an actual or prospective litigant before that body on an in personam basis, its purpose is nevertheless to restrain that body's proceedings. It's their effect that triggers the requirements that only if certain tests are met, that an ASI or an AAI will be granted. That effect and the need to meet the tests to achieve it does not change just because the person being asked is one person removed. And I would submit that if you agree that you cannot enjoin Sonny to stop the Brasi proceedings, that same effect cannot be achieved by asking Frido to do it. I'm sorry. It does.
Thank you very much. Ms. Davies?
Thank you. Just three, hopefully, short points in reply. The first one in response to the suggestion that there's a two-stage inquiry, i.e. one stage before you get into vexation in relation to the injunction against Sonny, and that is establishing whether England or this tribunal is the natural forum for resolution of that dispute. In my respectful submission, that's not an issue that arises because the issue here is collusion, and the authority for that is BNP Paribas versus Russian Machines, and there was no suggestion in that case that the bank had to establish first that England was the natural forum for the resolution of that dispute, nor could it have done had it been asked to, because just as in this case, what Ingestra in the Russian machines case sought to do was invalidate the guarantee on the basis that it hadn't received proper shareholder approval. That was presumably a claim that arose under the Articles of Association, which was properly a claim before the Russian court, as long as it wasn't collusive and vexatious. So you don't need to go through that hoop of natural forum in a case where there is collusion. The second point I wanted to make is that this is a very different case from BNP Paribas, and my learned friend suggested that that case was very fact-specific, and he's right. The court in that case did undertake a fairly detailed analysis of the Russian proceedings, and there were 9 factors that were listed in the judgment as indicating collusion beyond the question of common ownership. You'll remember I said earlier, in the Russian machines case, Ingestra, the trustee manager, was not in fact a related party to the Russian machines entity. It was a separate entity, and it was only a minority shareholder as the trustee manager. That was why the court in that case had to look at the 9 factors. I also referred you to the case of Mace versus Rettensell, in which there was common ownership and control, just as there is in this case. And in that case, the respondent to the injunction also sought to make exactly the same point that my learned friend is making, and it was rejected by the court. The court said, in the Ingestra case, it was necessary to consider the issue of collusion in some detail because the companies were not members of the same group, and therefore, on the face of matters, the shareholder was an independent actor. In the present case, in contrast, REL is the 100% owner of SPBR. That's exactly the case that we're in here. So that point, I'm afraid, doesn't take you anywhere. The third point is in relation to the Nearfield versus Lincoln case, which is the argument in relation to this being a neat workaround that you can't impose a procure obligation because there is no such procure obligation in the underlying contract as there was in the Nearfield case. All I cite the Nearfield case for is that a procure obligation is a C to it. It's an absolute obligation to do something. You don't need a contractual obligation in this case because you are exercising your discretion under the broad powers that you have to ensure the integrity of these proceedings, including under Article 26 of the Inter-Trial Rules. Unless you have any questions, those are my submissions.
Do my colleague?
Well, I'm just still a bit puzzled as how we can order a subsidiary to get a parent company to act in a certain way, that's all.
You can only do so if you're satisfied that there's been collusion. In principle, you can order Frido to do anything because Frido is within your jurisdiction. I'm suggesting that I think really the question is whether such an order would be effective to achieve the end, not whether you can do it. I think you can do it. The question is, will it be effective? And in my submission, it will, because Frido and Sonny have already illustrated that if you're satisfied on collusion, they've already illustrated that they are perfectly capable of influencing one against the other. Frido, if you find collusion, has caused Sonny to bring the proceedings in Brassey in order to undermine your reward in this arbitration. So I think the two stand or fall together.
But how do we police the order if Sonny just ignores it?
Well, that's why I ask for the second alternative. I'm not asking you to police it. I'm asking you to order in the alternative if they don't comply that Vito gets damages. That's the only policing you need.
Mr. Davies, I understood that you also had an application that we should order, and it may be an alternative, Frido, from assisting Sonny in the proceedings. Does that remain an alternative?
Correct. Yes.
Thank you.
Well, I think that concludes the oral submissions. Can I, on behalf of the tribunal, thank counsel very much for their succinct and very helpful and informative submissions. And I think the next stage of proceedings is for us not necessarily to say how we would have concluded, but for the members of the tribunal perhaps to make one or two comments, and then hopefully to open up to a question and answer session from the audience. So perhaps I can turn to my colleague on my right to see if he wants to add anything or make any comment.
I hoped I was George Berman and oft quoted. but it's just me. Can I say, indeed, how blessed we are that Kate and Tariq took time out of their very busy practices to give what I thought was a masterclass in oral submissions and dealing with questions from the tribunal. If this was Strictly Come Dancing, the couple would get 10 out of 10 from me. But I think this was a perfect example of the benefits of oral advocacy and the skills of well-prepared advocates and how they can present their cases and how they can really help the tribunal. If the tribunal asks good questions or bad questions, bring the uninformed questions back into and frame them on the issues and what the facts are. And I thought it was extremely well done. So congratulations, both of you. On the first issue, and I guess everyone could tell and the advocates knew, it's sort of a question of the integrity, not so much of the arbitration proceedings, but obviously the three of us, and I'm sure all of you, are concerned about the integrity of the award. And we were left in this position where the issues were raised that came out of cross-examination, maybe could have come up earlier, but excellent new counsel was starting to turn their minds to that. Well, we're not allowed to say what we would decide, but I think we would be quite concerned by that. And if you were looking at what the reasonable expectations of the parties when they entered into the agreement, that they provided for a consolidation of a second arbitration, I think is quite significant. On the second issue, we have seen quite a bit more of this recently, but I'm sure many of you have been involved in cases where there is these. I mean, it is essentially guerrilla tactics. It is collusion. I don't think you had to push particularly hard at that door. You know, but I think jurisdiction over Sunny is really quite problematic, and I think would be quite difficult. And I think relying on Delaware law for me was a very good try. You know, 4 marks for degree of difficulty, but might not have won the day for me. Sam?
Do you want to say something? No, I'll say something.
Sure. I mean, absolutely. I mean, terrific. Well done. I mean, superb. It would be nice to have skeleton arguments, because I think you may have exchanged them between the two of you, no? Or you're just inventing them totally? Okay, no, because that would be great. It'd make your life more miserable, but our life a lot easier, because we'd have a faintest idea what you're going to say. I slightly disagree with Audley in that I think the wording of the agreement, as Tariq said, actually plays in his favour. I think it's very revealing, and obviously it's completely bonkers, unusual agreement. But it is revealing that it says, in connection with a legal relationship in respect of which arbitration proceedings between the parties are already pending, any party may request that the claims contained in the request be included, and so on. And that seems to me to be saying, well, they've thought about this, maybe yes, maybe no. And they've actually left themselves a very unusual degree of leeway. And the reason I was asking you about the Toby Landau piece is that even though that's rather old now, I think it's very interesting, because he's saying, well, the abuse argument, does that really belong here? Because it's born out of public policy in front of the English courts. Whereas by contrast, you can see the role for it in international arbitration, absolutely. You've got to try and find a different slot for it. And he suggests, well, maybe there's an implied agreement, an implied term. And he's saying very much you've got to look very carefully at the arbitration agreement. So following his rule, although I thought you were rather weak on collateral attack, I think you might just look at this and to say, well, this is something they've actually allowed for, and there isn't enough here to say it's vexatious or an abuse. So difficult and interesting. On the second issue, I've sort of found that maybe I sort of seem to think of it as a bit more straightforward, perhaps in terms of collusion. Yes, clearly, but do we have the power? That's a real difficult one.
Well, let me add my comments as to the terrific performances of both of you. I think what was particularly unusual is that you were able to make your arguments both forcefully and clearly, succinctly, because we all know how long advocates normally take to make these points, and yet you got them over very clearly and very quickly, and we're enormously grateful to you both for all the hard work which has clearly gone into what you have done today. As to the two issues, the reality, I suspect, what would have happened in relation to the first issue is that there would have been some discussion as to whether, if we were minded to grant the injunction, would the alternative be something that Frida might consider, namely having the matter dealt with by this panel, but giving up on their different arbitrator. That may or may not have worked, but I suspect it would have been something that would have been discussed with the tribunal. As to the second point, I really share what my colleagues have said, and I'm not sure I can add very much to that. But I think now probably is the time for others in the room to make their comments and to ask any questions of either us or the two counsel. Perhaps anyone asking a question, I assume there are roving mics, could put their hand up and say who they are, please. Does anyone want to ask any questions? Or have the advocates answered all your questions? It may be that people would prefer to have a drink. Well, I think, therefore, if nobody has any questions, I'm not sure whether somebody from Three Crowns is going to come up at the end, or whether oh no, it's somebody from... I'm sorry.
It's my turn. I'm trying not to step on the table. Maybe if there's no questions from the audience, maybe you can ask the two advocates whether they want to say something, without being staged. What's your response to what the advocates say? Sorry, the tribunal. If you want.
Well, thank you, first of all, in particular for asking such good questions in circumstances where you hadn't the foggiest clue what we were going to say. I also didn't know what Tariq was going to say on the second issue, so that was all a surprise to me as well, but thank you. And I do actually think, and I take this as a point against myself, because I know I will never be asked to do this again, having done it once. I think the idea of skeletons is brilliant. I think you should introduce that for future years and future advocates. It's a brilliant idea.
You might get even more difficult questions.
No, I do think it's a good idea. If anybody wants to know what happened in the real case that this is based on, they can come and ask me afterwards.
I'm ready for a drink.
Perfect. So just a few final words to say thank you for the two advocates, Kate and Tariq, as well as the distinguished member of the distinguished tribunal that has really groomed quite extensively our two advocates, Sam, Audley, and Hilary. But also want to thank Three Crowns, who has supported the event, over the years and also this edition, as well as the very diligent and efficient staff that has put this together, Anish, Annie, and all the staff that have really helped. I want to say something. I'm here on behalf of King's College London, one of the partners in this endeavor, but I also want to say something on behalf of George Berman, who unfortunately could not fly over from New York and broke his record of always being present at all the past events. I'm sure he's very sorry, but again, he's really, this is indeed a collaboration among the three institutions. And so finally, a thank you also to you, the audience, for coming here, and hopefully we have a chance to talk at the reception. Now, drinks are downstairs in the library, so make your way down, and it's the big room in front of the entrance. Goodbye.